Data protection and privacy teams are under more pressure than ever with new laws, AI oversight, data breaches, and the constant expectation to do more with fewer resources.
That's why TrustArc built a modern privacy and data protection management platform powered by Arc Intelligence. It unifies your tools, automates the work that slows you down, and surfaces what matters most right when you need it.
From guided quick actions to our intelligent assistant, Ask Arc, you get credible, contextual answers backed by expert research, not generic AI guesses.
Finally, privacy that works the way privacy pros work.
Learn how TrustArc helps teams move faster with confidence at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.
You're listening to Serious Privacy by TrustArc. Please welcome our hosts, Paul Breitbarth and Kay Royal.
Privacy professionals in the EU and the US had the 16th of July marked on their calendars for a long time. This was the day the Grand Chamber of the Court of Justice of the European Union would publish their verdict in the case between the Irish Data Protection Commissioner on the one hand and Facebook and Max Schrems on the other. The Schrems 2 case, as it is commonly known, has made as much of an impact as its predecessor did in 2015. On Thursday morning, the court invalidated the EU-US Privacy Shield and seriously restricted the use of standard contractual clauses. Reason enough for a special Serious Privacy episode to discuss the case and what comes next. My name is Paul Breitbarth.
And I am Kay Royal, and welcome to Serious Privacy. So we're going to dive very quickly into the substance of our podcast today, but we cannot forget the tradition we have of an unexpected question. So before we introduce our distinguished guests, the unexpected question coming to Gabriella and Sophie is, may I call you Gabriella and Sophie?
Yes. Please do. Please do. We're Dutch. We're very informal. Always on a first name basis.
Perfect. Thank you.
Thanks, Kay. And indeed, we have great guests today. We have the distinct honor to welcome to the podcast our first politician, member of the European Parliament for Renew Europe, Sophie in 't Veld from the Netherlands, as well as my former colleague in the Working Party 29, Gabriella Zanfir-Fortuna, who is currently at the Future of Privacy Forum, but at the time of the Schrems 1 decision was still at the European Data Protection Supervisor, where we were part of the same team analyzing the decision and also preparing the Working Party's response to the first draft of the Privacy Shield. Gabriella, looking back at those days and reading the verdict today, what is your first response to the Schrems 2 decision?
Hello, Paul, and hello to Sophie. It's such a pleasure and an honor to be part of the podcast with the two of you today, and with Kay, of course. My first reaction was that I was surprised that the court parted with the Advocate General's opinion, who, as we remember, suggested that the court could postpone a bit a decision on the Privacy Shield and focus on the validity of the standard contractual clauses. And then my immediate reaction after that was, while reading the arguments of the court, to think about the evaluation that the Article 29 Working Party has published when the Privacy Shield was still in a draft back in 2016, and where the Article 29 Working Party, and now the European Data Protection Board, expressed concerns in relation to the same type of issues that the Court of Justice identified with the Privacy Shield adequacy framework.
And Sophie, what did you think this morning when you saw the verdict of the court? Were you happy? Is this as expected?
No, I'm not happy. Of course, it's good to see that we can always rely on the European Court of Justice to do the right thing. But I'm a bit exasperated because, how often can we think, told you so, told you so, told you so? I mean, we knew this. The European Parliament has called for the repeal of Privacy Shield repeatedly. The EDP, so many people, so many experts have told the European Commission, look, it is not legally sound. And the Commission just very stubbornly, of course, under pressure of the member states, pretended that Privacy Shield was going to stand the test in court. And I think the Commission knew all along as well that it was fooling itself. And this all has to do, it's not a legal issue. It's not a technical issue. It's a political issue. This is all about the transatlantic relations and the fact that the European Union, represented in this case by the European Commission, is just not strong enough, not courageous enough to look the Americans in the eye and say, dear friends, we're now going to negotiate, at equal level. We respect you, your system, your markets, but you have to respect us and our laws and our markets as well.
What's surprised me actually is indeed, first of all, that the court did decide to rule on the Privacy Shield, but maybe even more so the immediate response from the Department of Commerce afterwards, saying, oh no, but we will continue to administer the Privacy Shield pretending like nothing has happened today here in the European Court. So apparently here in Europe, Privacy Shield doesn't exist anymore, but in the United States it does. Kay, what do you make of that, you being American?
I would love to say that doesn't surprise me whatsoever, but of course it surprises me. For some reason, we seem to think that we are the largest power in the world and that what we say goes, and to heck with anyone else's opinion. And essentially, we're ostriches burying our heads in the sand. But I will say, talking to my privacy colleagues and listening to other people talking already this morning, that is not the opinion of the majority of the United States. That is apparently only the opinion that was published on the Department of Commerce's website.
Sophie, do you expect anything from this? Is this the U.S. way of saying, well, there will be quick negotiations, we'll make some cosmetic tweaks, and then it should be fine again, and then we wait for another 4 years before the court once again strikes down a successor?
I think that is what many people would like, because the thing is that, they now have to look the monster in the eye. And this is, I would not blame the United States in the sense, they're just going as far as the Europeans allow them to go. And this inequality of the relationship is, it takes two to tango. And I think maybe the US occasionally are a bit excessively arrogant, but at the same time, the Europeans are too submissive, too timid, because how can you explain to people that the European Commission, which is supposed to represent the interests of the Europeans and to defend the European laws, how can I explain to European citizens that the Commission actually puts its diplomatic relations with the United States over the rights of European citizens? I blame the European Commission and the member states much more for this than I do the US side. They're protecting their own interests. I can't blame them for that.
Is there already a debate scheduled in the European Parliament on the follow-up of this?
I've asked, because, today was just the last day before summer recess, but I've asked for the European Commission to appear before Parliament immediately after the summer break, so end of August, early September. I suppose they're going to need some time to look at this. But the point is that, there is no easy solution for this. And if this were any other country, if this were China, if it were Russia, if it were, Brazil, then the European Union would be very assertive and say, hey, you need to adapt to us. We are a big market. We have 450 million consumers. If you guys want to do business in Europe, you have to comply with our standards. But when it's about the United States, all of a sudden we change our tune completely. And the point is that as long as the surveillance laws are what they are in the United States, and as long as there is this differentiation between, let's say, legal protection of US citizens and non-US citizens, there cannot really be an arrangement that complies with EU law. So something will have to move. And I think that it is time that the Europeans say, dear American friends, you're our best friends, you're our closest allies, but you too will have to move.
Gabriela? We're frenemies.
Gabriela?
I would have to agree with Sophie on the point that this, at this point, is a diplomatic relations matter more than a compliance matter. And this is really something that's intergovernmental level type of conversation that needs to take place. And I also agree that I think the US is in this privileged position with Europe and with the European Commission precisely because there are so many common values and precisely because we are best friends, just like Sophie said. I also recall a very recent interview that Wojciech Wiewiorowski, the current European Data Protection Supervisor, recently gave to Politico, where he was mentioning that certainly the US is the third country with which we share most common values, and especially if we compare that to other countries like China, he was saying. So, this indeed sets the framework just like Sophie mentioned. As for the reaction of the Department of Commerce, that was indeed a bit surprising to see that. And my first reaction was to think that they are disregarding the judgment of the Court of Justice. And then I had a conversation with a couple of my colleagues, and I understood that the fact that companies will still be held to the standards set by the Privacy Shield as far as the US is concerned, not as far as the Privacy Shield being a lawful mechanism for transfer from the EU to here, actually protects the data that has already been transferred. And as you know, here in the US, a lot of the privacy protections come from the promises that companies make publicly. And because those promises can be held, companies can be held to those promises under Section 5 of the FTC Act. So I'm thinking that it's a good thing that the Privacy Shield will continue to apply to American companies. But we have to recognize that starting from today and with no transition period, the Privacy Shield as a mechanism for transfer that ensures lawful transfers does not exist. It's invalid. This is what the Court of Justice decided.
But the point is, well, first of all, it's not about companies. It's about public authorities. It's about intelligence agencies, law enforcement agencies. So companies can promise whatever they like. And that's also very clear from the ruling of the court. Secondly, I'm no lawyer, and I'm sure that specialists know better. But how could it be that data which have been transferred under the Privacy Shield so far, how can they be protected if the Privacy Shield was considered to be inadequate? Then any protection they had was inadequate protection. And again, it was
just an image.
Yeah, they were never protected from the data grab by the secret services. Of course, there's also the SEC, the standard contractual clauses, and some people are saying, this is grand. We still have the SEC, so we can still transfer the data. But if you read and they were not affected by or rather the court didn't invalidate the SEC, but the court did say the SEC have all the appropriate safeguards, but they have to be applied. And that means that DPAs have to come in if they consider that, for example, a law in a third country, in this case US, would take precedence over the SEC. So I think in practice they're not very, very useful either. So something will have to move. And I think if the US side has already taken some steps in terms of offering judicial protection, offering more rights to EU citizens, but there are too many loopholes. I think the only way to get out of this is for the US to say, okay, EU citizens will get the exact same protection and the exact same rights and remedies as US citizens, the way it is in Europe. I mean, in Europe, you have those protections, whether you're European or American or Chinese, doesn't matter. And I think that would resolve a lot of issues.
Mm-hmm. What I would add here is that I've been in the US for close to 4 years now. And, US citizens don't enjoy the same level of protection for their privacy in the US by the US government or companies as EU citizens enjoy in Europe. And this is something that's a bit clear in the interactions that I follow, especially with regard to the entire legislative process that's has been happening in the US in the past 2 years or so, with many bills being proposed for comprehensive privacy and so on. So there's also this nuance that I kept thinking about when I was reading the part where the court was criticizing the lack of judicial remedies and private right of actions, effective judicial redress. I have to highlight that one of the hottest potatoes to deal with when the US right now is negotiating new laws, be it at state level or at federal level, is in fact the existence of a private right of action for citizens under commercial privacy. So this debate right now is very robust here in the US, where Americans, for themselves, are trying to figure out how to best find a solution for having a high level of protection of their privacy. So I don't know what Kay's take on this would be, but these were also some of the thoughts that crossed my mind when I was reading.
Kay?
No, I cannot disagree with any level of that.
Well, that's
the simplest way to put it.
No, that's absolutely helpful coming from the US. Why don't you speak on behalf of the government? That would make all our lives a lot easier. I was actually
well, if the government would listen to its people, maybe this would be solved a little quicker.
What was it? Government by the people, for the people, something like that?
Exactly, but apparently not of the people.
What I liked in the judgment today, apart from seeing a lot of the Privacy Shield arguments that we made in the Working Party 29 in 2016, was actually the section on the standard contractual clauses, because the court has given a lot more clarity on the responsibilities both of the organizations themselves and of the supervisory authorities in enforcing the standard contractual clauses with the additional criteria. Basically, what the court has done is extending the so-called essential equivalence requirement that we knew since Schrems 1 for adequacy decision to every single transfer instrument that exists. The court says if you think that the standard contractual clauses are not sufficient to protect the data that are transferred under your responsibility, because there is other legislation in the country where the data is going to, then you need to have additional criteria in your contracts. And if that is not possible, then you should stop transferring the personal data, end it, suspend it, never start it at all. And if you don't do that as an organization, as a company, then it is up to the DPAs to suspend those transfers. And I think that is much clearer than it has ever been communicated before.
Right.
There is a strong responsibility on companies now to reassess their standard contractual clauses. It is not just signing the contract that everybody has done blind and then forget about it in the past decade. It is actually serious assessments that are now required.
I think ultimately, and that's why I said, people who were jubilant saying, oh, but we still have the standard contractual clauses, so we're fine. Of course, they're not fine, because as you rightfully point out, the judge just said, but they have to meet the same standards.
Right.
So if the American surveillance laws, don't change, whether it's the Privacy Shield or SEC or whatever instrument you're using. I mean, that fact that the surveillance laws will always take precedence, that you don't change. And now the interesting question is whether, the DPAs also have a big responsibility here, the European DPAs, whether they are actually going to enforce. And in particular, the Irish one. They are put on the spot now. And GDPR has been enforced for just over 2 years. We've just last week discussed the evaluation of GDPR. And the most remarkable conclusion is that, yes, we have the best privacy law in the world, but enforcement is pathetic. National DPAs are completely understaffed, underfunded, don't have the necessary powers, and then sometimes there may be political considerations that make them hold back. I've even heard some DPAs say during the Corona crisis, saying, "Oh well, we're in a time of crisis now. This is not the right moment to enforce our data privacy laws." And I thought, I actually think this is a very good time.
It's a good time to do it.
Yes.
And I wasn't sure if you were talking about European government or U.S. government there.
Well, that would take another podcast, I think. But no, and enforcement is going to be a big issue because enforcement is really, really bad. And what you said, what Gabriela said earlier about whether you as citizens actually have adequate legal protection and legal rights, maybe not in every detail when it comes to data protection and privacy protection, but there are also other elements. This is not just about privacy and data protection. This is about all sorts of legal safeguards. If your data are being used by the NSA, CIA, whatever, and you are being falsely accused of something, there has to be the right to legal remedy, the right to go to court. And I think American citizens probably have more protection. If you look at the European Union, if you have to litigate, look at how long Schrems has been litigating. Those processes are so cumbersome. I'm always inclined to say justice delayed is justice denied, and we're not far from that. And secondly, something which I really, really like about the American system and the American culture is you have a very strong culture of transparency, access to information, access to documents, which really strengthens the position of citizens. You also have a very strong tradition of strategic litigation that I'm really envious of. And we need a lot more of that in Europe, I think.
That is certainly true. And if you think about the time the justice took, but also the cost, I saw a report from Max Schrems earlier today that this whole case has cost over 10 million euro just for one case, for one person to go to court. And it isn't over yet because today's court decision of the Court of Justice of the European Union is basically only answering a few questions from the High Court in Ireland that now has to make a final decision in the coming months. And then it has to go back to the DPA, and then there will be undoubtedly further appeals, whatever decision they make.
And all of this could have been avoided if the European Commission would have had the guts to just say, dear American friends, dear governments in the European Union, this is the law, this is the European law, and Privacy Shield doesn't comply. Because this is it, the European Commission is it's the guardian of the treaties, as we say. They are supposed to enforce the law, but they're not doing it. So now an individual citizen had to go to court, basically take the Commission to court and make sure that the Commission is going to enforce the law. That's crazy if you think of it. That's not the idea. A court is supposed to interpret the law where there may be different interpretations and people cannot agree. But in this case, the Commission knew full well, because everybody had been advising the Commission and they just did not want to hear. So this could all have been avoided. And, now they will have to grow up fast and sit down with the Americans and do some serious negotiation.
Yes, you are absolutely right. Gabriela, you are known, at least in the privacy community, for always writing extensive analysis of groundbreaking case law. How does this fit into your register of case law, and what are the remarkable points that you will highlight in your analysis?
Well, there are many interesting points. The first thing I would highlight is that this is just the last case in a series of cases of the Court of Justice that I would say started with Digital Rights Ireland, clearly. There might have been elements of the court's vision in previous cases, but I'm not really spot on aware of any. So I would say it started with Digital Rights Ireland.
About the retention of telecommunications data, right?
The case where the Court of Justice decided to annul the entire data retention directive, even if it was just asked about one of the directive's provisions. And then that's when the court found that access to metadata of electronic communications can actually be a serious interference in the right to private life, and took into account all of the elements of the case and decided the data retention directive should be invalidated, annulled, actually. Then we had other cases. We had Tele2Sverige, which was sort of a follow-up case of the data retention debate. And the court again came with strong privacy protections, data protections for these two fundamental rights. We had Schrems 1, of course. We had EU-Canada PNR, the EU-Canada PNR opinion, where the court again pushed for a very high level of protection. So, this just comes to confirm that the court cares a lot about this and does not want to look back and tweak or, do some things around this strong stance that it has. So it just keeps drilling and pushing forward. That's one thing that I think it's important to mention. The other bits and pieces of analysis that are interesting, well, they are many. And you actually touched a bit upon a couple of those, Paul, when you referred to the standard to which standard contractual clauses should be compared or should be held against. And the court finding that standard contractual clauses, just like an adequacy decision, should be held to the standard of an essentially equivalence being present in the framework that they create. And I think this indeed will raise difficulties in having strong, lawful standard contractual clauses in place for transfers. However, the court did find a sort of what I would call like a small door, let's say, or a valve, if you want, for continuing to use standard contractual clauses for some transfers, case to case, because the court, even if it says that standard contractual clauses should be held to this essentially equivalent standard, however, they are a valid instrument regardless of the level of protection in a certain country. That's in paragraph 133, I believe. So they are valid, they can be used. But in order to achieve that essential equivalence, you might be able to add additional safeguards or additional measures. The court uses a couple of different words in these two paragraphs, 133, 134. And for example, I was thinking of encryption. Maybe you can provide encryption of the data that you want to transfer, and this would somehow help. But again, we cannot decide that from the outset. We will have to see in each case if that is really feasible, and this is going to be complicated. However, there's this entire situation. And just to end with the interesting bits and points, still about the standard with the high level of protection, I'm very curious to see whether the court believes that also the derogations under Article 49 of the GDPR, to which the court actually points in its last paragraph in the judgment, should also be held to that same standard, because that would indeed mean that it will be almost impossible to go on with data flows between Europe and states that do not have a sufficient level of protection as required by EU law. So that's one thing. And then there are others, interesting things for the geeks, like the court saying that we're not interested in the European Court of Human Rights standard for accessing data by national security agencies, because we will apply EU law when it's about national security of non-EU member states. So that was one interesting bit of the judgment as well. And I will stop. But you are right, Paul. If I start, drilling into these decisions, I can go on and on.
Almost every paragraph seems to contain an interesting statement from the court, at least in my view. I've got a long list of paragraphs that I want to take a look at again in the coming days. But Kay, I think you had some follow-up questions here as well.
I do. And where mine comes from is looking at it from the businesses here in the U.S. or from businesses anywhere, but mainly here in the U.S., is what should they be doing now? What is the practical takeaway that companies that either didn't realize this decision was coming, which I don't understand how that could happen, but for companies that may wake up this morning, or privacy professionals that wake up and they're like, oh, pooty. Yes, I say, oh, pooty. Oh, pooty. What do I do now?
Well, I think first of all, they will need to make an inventory of all the contracts that contain standard contractual clauses and start to assess
If they
whether or
have
not
them.
they are at risk. If they have them. But if they do have them, start assessing whether or not they are at risk. Is this data that would be subject to any of the surveillance programs that the court refers to? So Section 702 FISA, Executive Order 12333, Presidential Policy Directive 28. It might already be possible to at least deduce, are the data that you are transferring and is your company likely to be subject to any of those programs? If so, you may want to reconsider, at least temporarily, relocating your data to Europe, if that is possible at all. If you are Privacy Shield certified, then that will take a bit of time to make a decision. In any case, we probably hear tomorrow from the European Data Protection Board whether or not there will be a grace period, like there was following the Schrems 1 decision, and what their intentions are for the way forward. There will be new standard contractual clauses. The European Commission has announced already today that they are almost ready. We knew that they were almost ready and that they were waiting for this judgment before they would be finalized. So they should be ready in the next couple of months. Hopefully they should be enforceable by September. But companies will really need to start to review again their data processing practices. A full effective answer I can't give yet, because we don't know what the governments will do and what the European Commission will do and what the data protection authorities will do. So far, the statements have been very much summary statements. We'll look into the verdict.
Well, that's what they always say. Yeah, but I think there's going to be a grace period by definition, because I don't think that the DPAs are even prepared in every sense of the word to start enforcing in a strict manner. And I think the commission, because the commission apparently already expected this outcome. Already a couple of weeks ago, the commissioner said, "Oh well, we're waiting for the ruling, but we have a fallback scenario." So we'll see whether that is something that will stand which will be Schrems proof, as we call it here. We'll see. I mean, I still think that if nothing moves on the US side, nothing will ever be completely Schrems proof.
Right.
And I think if you have, apart from the immediate practical and legal measures that companies should be taking, I mean, rather than trying to arm twist the European Union into accepting something which is in violation of European laws, maybe they should lobby the US authorities for a change in the legislation. That's one thing. And the other thing is that ultimately, but this is more long term, I've been calling for something like, let's say, the equivalent of the Paris Agreement for climate laws. We would need something similar for privacy. So a Paris Agreement for privacy, and I've just asked the European Commission something which is binding, something which everybody knows. And of course that will be a low level of protection, but at least there should be some basic criteria that everybody has to meet. And I think this is also because, okay, now we're all looking at the US, but of course the next problem is going to be China, Russia, which is going to be a perpetual problem, I suppose, Africa, because, okay, we all think that Africa is just a kind of eternal third world continent, but I don't think so. There are lots of things happening in Africa. And I think lots of, the Chinese, but also others, they're already firmly established on the African continent. They're doing a lot about development, digital development. So, and of course, privacy doesn't exist there. Mm-hmm. So I think rather than waiting until Africa has developed and they're having their own digital champions and what have you, it would be better to now all sit down together globally. And this is something where, I've asked the Commission to take an initiative, maybe in the context of the United Nations or something like that, something very similar to the Paris Agreement, and see if we can move this forward, because there can only be a global response to a global challenge.
That is true, and I like your idea of the Paris Agreement, other than the fact that the U.S. is withdrawing from the Paris Agreement.
We could call
But
it,
I like that idea.
Let's revive multilateralism. There are elections coming up, so there is an opportunity in November and see if, and I'm not saying, because of course, Trump is really not the only problem in the world, and he's really not the only problem for transatlantic relations. But let's say that having somebody else there might actually enhance the chances of finding agreement and cooperation. And I think somebody else in the White House would at least be more open to, restoring multilateralism, restoring transatlantic relations, restoring the whole notion of compromise, cooperation, consensus.
So first of all, I think we can call it the Dallas Agreement, Dallas, Texas, or we could find one of the, just to make it appealing. But what I would actually want to add, and very seriously, is that the opening statement in the opinion of the Advocate General in this case was this: in the absence of a global data protection standard, data flows from Europe are always going to be
there you go.
jeopardy in the sense of. So this is how the Advocate General started his entire, construction of the case, and I found it very interesting. I also heard something in a recent webinar between Microsoft's president, Brad Smith, and Commissioner Vera Jourova. Actually, it was a webinar about 2 weeks ago, and he was mentioning something about what about a global charter for privacy? And this is, of course, an entire other discussion about privacy and data protection, but we leave that for another time. But still, I see this idea coming up and appearing, and maybe it's something that we should discuss. And here, to finalize on this point, I also saw our friend Sophie Kwasny from the Council of Europe tweeting today after the judgment that, hey, look at Convention 108, Convention 108 plus, and maybe, get some ideas about whether this could be a solution for third countries that want to have additional safeguards for the protection of personal data.
But I think because look, we're not starting from scratch. There's already a lot out there, and the whole idea that the US is sort of is like a desert when it comes to data protection is of course not true. But I think what the Paris Agreement has is it's a political project. It's very visible. Most citizens, if you look at the whole, what they're called, with Greta Thunberg and all the youngsters who are taking to the street. Not the Green Deal. Anyway, but I can't remember now. But there are all these demonstrations, all these campaigns
Fridays for Future
on climate change, and so for them, for a whole generation, they all know the Paris Agreement. They know what it is. They know what it stands. They may not have read every paragraph of it, but everybody knows that there is a global agreement, a global commitment. And I think this is so. Of course, the negotiations will have to be done by all the experts and the stakeholders and what have you. But I think what is very important is that we make it a political project, which is being discussed in public, where people can buy in. I mean, it should be possible for teenagers to take to the streets on Fridays and say, I'm demonstrating for a global agreement on privacy protection, something like that. So it has to be something which is really out in the public domain.
This is really essential because, Sophie, just like you said, yes, the US has been under scrutiny ever since the Snowden revelation for the mass surveillance practices. But if we start looking at China, if we start looking at Russia, there will be some issues there. And I've seen recent studies that, contrary to expectations, there are a lot of data flows that go to China due to these new apps, like TikTok and all of these new apps. I'm not very familiarized with all of them, but still, this has been accelerating in the past couple of years, very recently. So I already can see that how this conversation can have immediate global effects for all these relations between Europe and the other big economies of the world. So really, really urgent topic.
Before we wrap up, any final points that either of you wish to make?
There are 25 points that I could think of, but I don't think the idea is to have a podcast of 24 hours. But no, there's so much in this. It's, of course, people can look at it from a legal angle, from a privacy protection angle, from a practical business angle. I like to look at it from a political angle and say, what does this say about the maturity of the European Union as a political entity? Of course, for me, that's very important. And I think the message here is, Europe, grow up and grow up fast, because it's a big bad world out there. And, if you want to protect the interests of your citizens, then you have to use the power. I mean, we are an economic heavyweight, but we're not using that power at all. And I think we should start doing that.
My thoughts to conclude this debate, and something that I didn't mention before, is that I think we as global citizens need to start thinking and acting about surveillance for national security purposes. And let's not forget that as recent as last month or 2 months ago, the German Constitutional Court found that the surveillance regime of Germany with regard to foreign nationals was not constitutional. So there were proportionality issues there as well. However, great points for allowing foreign nationals to go before the Constitutional Court, so that the Constitutional Court had the opportunity to reach that conclusion, right? But this does not take away the fact that similar concerns were raised about national security surveillance practices from Europe as well. So this is certainly a topic that would need even more attention than we gave this topic before.
Well, with that, thank you both very, very much for jumping on this call so quickly after the verdict was released, and for joining us for today's recording of Serious Privacy. And to all our listeners, I'll say, if you like our series, please do tell your friends and colleagues about us. Subscribe in your favorite podcast application. And should you have any questions or suggestions, if you wish to hear from any privacy professional in the world, just let us know and reach out to us via seriousprivacy@TrustArc.com or via Twitter at @podcastprivacy. You will find Kay on Twitter as Heart of Privacy and myself as EuroPolB. Thank you again for listening to today's episode of Serious Privacy, and until our next one, goodbye.
Bye, y'all.
That was Serious Privacy.
If you're a data protection or privacy professional, you already know the pressure: non-stop regulatory change, AI oversight, internal demands, and the expectation to somehow stay ahead of it all. And the old patchwork of tools just isn't cutting it anymore.
No, that's why TrustArc created a modern privacy management platform powered by Arc Intelligence. The TrustArc platform brings your workflows, evidence, research, tasks, and applications all together in one unified and intelligent workspace, so you don't waste time digging, clicking, or context switching.
With Ask Arc, your privacy assistant, you can ask plain language questions about laws, jurisdictions, or even your own program data, and get credible, cited answers based on NIMBY research and more than 1,000 global laws. It's explainable, transparent, and purpose-built for data protection and privacy.
So if you need to add a vendor, create a cookie banner, or start an assessment, quick actions take formally complex tasks, turn them into bite-sized guided workflows to save you time.
It's a platform that thinks like you, works like you, and helps you move faster with confidence, whether you're a seasoned DPO or you're just getting started.
See how modern privacy gets done. Explore Arc at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.